There's big news unfolding in the ongoing push to finally remove short-barreled rifles and suppressors from the grip of the National Firearms Act. If you've been following the saga, you know that both the Hearing Protection Act and the Short Act were rolled into House Resolution Number 1, better known in gun rights circles as the Big Beautiful Bill. The problem? These provisions only took aim at the $200 tax stamp. That's it. The rest of the overreaching bureaucracy behind the NFA remains untouched. Because of that half measure, we're now seeing a surge of fresh legal action with one goal in mind: to dismantle what's left of the outdated registry requirements and regulatory overreach still applied to suppressors and short-barreled rifles. Let's unpack what this really means. To start, House Resolution Number 1 recently made it through Congress. Tucked inside were reworked versions of the Hearing Protection Act and the Short Act. But instead of scrapping the National Firearms Act altogether for these items, lawmakers just eliminated the tax. That means the old $200 fee to register suppressors or short-barreled rifles is now officially zero. Sure, that's a win, but let's be real. It's nowhere near the full repeal many of us were hoping for. Personally, I wanted to see the entire National Firearms Act gutted, especially the sections dealing with silencers and short-barreled platforms. But, as expected, a handful of so-called moderates within the Republican ranks didn't have the backbone to back a full repeal. They wouldn't even remove the Senate parliamentarian to push it through. So we ended up with a stripped-down bill that removed the tax but left the rest of the NFA's unconstitutional restrictions fully intact. Here's the good news, though this fight isn't over. Not even close. Now that the tax stamp is officially gone, several prominent pro-gun organizations have stepped up and launched legal challenges aimed directly at what's left of the National Firearms Act. Gun Owners of America, the Firearms Regulatory Accountability Coalition, Palmetto State Armory, and Silencer Co. have all banded together and filed a federal lawsuit targeting the Bureau of Alcohol, Tobacco, Firearms, and Explosives. And that's just the first wave. From what I've been hearing, another major lawsuit is in the pipeline, this one backed by the Firearms Policy Coalition, the National Rifle Association, the Second Amendment Foundation, and likely the American Suppressor Association. Each of them is preparing to challenge what remains of the NFA's unconstitutional framework. The fight to fully restore our rights is far from done. It's just entering a new phase. In the legal action already filed, Gun Owners of America and its allies are arguing that the National Firearms Act, first enacted back in the year 1934, was only ever upheld on the basis of Congress's power to levy taxes. Back then, lawmakers imposed a $200 tax on the manufacture and transfer of items like suppressors, short-barreled rifles, and other restricted weapons. That tax was the foundation for the law's legal standing, and the Supreme Court upheld it solely on that narrow justification. For nearly a century, that's been the accepted legal precedent. But everything shifted on July 4th, 2025, when House Resolution Number 1 officially went into effect. One of its key features was wiping out the $200 tax on most NFA-regulated items. In practical terms, that means the legal backbone of the NFA, Congress's taxing power, no longer supports the law when applied to those firearms. Without that tax in place, the law can't be defended under Article 1 of the Constitution anymore. According to the lawsuit, while the tax was removed, all the other federal restrictions, registration mandates, transfer rules, and manufacturing approvals were left standing. And since there's no longer a valid tax behind those regulations, the plaintiffs argue that the law now floats without a constitutional foundation. That's why the suit brought by both individuals and major firearm advocacy groups is asking the federal court to strike down the National Firearms Act as unconstitutional, at least in cases where the items are no longer taxed. The lawsuit makes two key demands. First, it seeks a declaratory judgment, a formal legal ruling that the NFA, in its current form, exceeds the power granted to Congress under Article 1. Second, it requests an injunction to block the Bureau of Alcohol, Tobacco, Firearms and Explosives, and other federal agencies from enforcing any NFA-related rules against firearms that are no longer subject to the tax. That includes short-barreled rifles, short-barreled shotguns, sound suppressors, and anything else the government considers an any other weapon. This legal challenge is being brought in the Northern District of Texas, a court that's earned a strong reputation for handing down pro-Second Amendment rulings. This is the same district where landmark wins like the Vanderstock case, which tackled the issue of so-called 80% receivers, and the Mock case challenging the ATF's brace regulation, both came from. What many of us in the gun community are hoping for now is a judge like Reed O'Connor, someone who understands firearm laws inside and out, and who's not afraid to call out federal agencies when they stretch beyond what the Constitution allows. But no matter how solid the decision is at the district level, we're almost guaranteed to see it pushed up the chain. This case will end up in the Fifth Circuit Court of Appeals, where the terrain gets a little trickier. Thanks to a recent ruling from the Supreme Court, a 6-3 decision broad, nationwide injunctions are pretty much off the table for now. So even if the plaintiffs get a win in the Fifth Circuit, the decision might only apply to members of the organizations involved in the case or the customers of the named plaintiffs. And let's not forget, the Fifth Circuit has a track record of pausing rulings in gun cases. That means any order striking down parts of the National Firearms Act could be put on hold until the Supreme Court gets its shot at the issue. Now, if the court were to go all the way and declare the NFA's core framework unconstitutional, that would be a massive win for gun owners across the country. But in reality, even if that happens, don't expect immediate change. Based on previous cases, the Fifth Circuit would likely delay the enforcement of such a ruling to maintain judicial caution. This isn't just guesswork. We've seen it unfold before, with similar lawsuits from the same region. One wild card in this whole fight is how the Trump-era ATF might respond. Over the last year, we've seen them reverse course in several high-stakes gun-related lawsuits. There's a real chance we could see the agency adjust its stance without needing a major shove from the courts. If the ATF openly admits that killing the $200 transfer tax has gutted the NFA's legal backbone, that would be a major development. If they concede that without the tax, they lack constitutional authority to enforce registration or transfer restrictions on untaxed firearms like suppressors and short-barreled rifles, it could change everything. Honestly, I wouldn't be shocked if the ATF does exactly that. The Trump administration has already taken some surprising positions when it comes to defending the right to keep and bear arms. And this could be another example of that. For now, all eyes are on whichever judge gets assigned to this case. The outcome could hinge on whether we get someone who respects the Second Amendment and understands the legal boundaries placed on federal regulators. Someone like Judge Reed O'Connor, with a solid track record of standing up for constitutional rights, could make all the difference here. With both the Hearing Protection Act and the Short Act now officially passed through Congress, complete with that $0 tax provision, the legal war is shifting to clear out the rest of the unconstitutional leftovers the National Firearms Act still imposes. Credit where it's due. Gun owners of America, alongside their allies, are leading the charge in court and putting in the work to undo decades of federal overreach. Their mission is simple: get rid of the rest of the NFA's mandates that no longer have any constitutional support, now that the tax system they were built on has been dismantled. I'll be watching this case closely and will keep you posted as things develop. Thanks for tuning in. Don't forget to like, drop a comment, and hit that subscribe button. And remember, this country was built by armed scholars, and it's going to take armed scholars to defend it.